get started now, although the tech aspect is still being sorted out. So, on behalf of Lexion, the publisher of the Edpl journal, just a few words to kick this off. So, when we started the Edpl journal, our idea was to offer a forum of high quality that is inclusive of different perspectives. So we have been inviting some of the leading names in academia, from the regulatory side, business, to speak through the pages of our journal. And especially in such a young and dynamic field as data protection, you can't neglect the perspective of the new generation of experts. So this is why last year we started for the first time the Young Scholars Award. This is the second edition, as our way to offer young experts a platform to get their voice heard. First with a special issue of the journal, issue 4, that you can pick up from the table in front. And also thanks to our friends from the organizing committee of Cpdp, to have this panel where we invite the best 3 competitors to present their work. So I won't eat up any more of their time, and I will hand over to our managing editor and head of the jury, Bart.
Welcome, everyone. I will explain a bit about the procedure for the Young Scholars Award. So we provided a call for papers to everyone to contribute. We had about 20-25 submissions. I've rejected 15 of those immediately and selected only the 10 best for jury selection. I was the head of the jury. Maya Brakan, who's sitting there, was the second jury member, and Franziska Boehm was the third jury member. She couldn't be here, instead being replaced by Mark Cole, who's also on the editorial board. So from the 10 papers, we selected the 5 best for publication in the journal. The 3 best are going to present their paper here, and the best paper will get Eternal Pride and a prize by Serge Goodworth, who's sitting here, which is already enough, I think, for your life to be complete and full. So we chose, I think, the articles based on the difficult names for me to pronounce, but I will try anyway. We have 3 contestants here. Eike Gräf, yes, who is working in Germany, but also living partly in Brussels. He's part of the iRights lab, which is a difficult consortium of all kinds of initiatives. The second is Zarine Kharazian, almost, who's working in Washington, D.C. at the moment at a law firm, and then Anne-Laure Philouze, perfect, who is working here in Brussels at the Brussels law firm. So they will present each their paper. First Eike, then there's a comment, then a second presentation, then a comment again from the jury, third presentation, comment by the jury, questioned by you, of course, and then the prize handing over. Okay, Eike, do you want to start?
Yes. Okay, this is not too loud. I just wanted to say first, we are sitting like this not because we don't like each other, but the light is very, very strong and you just cannot sit there without being blinded after 2 minutes. So, yeah, thank you for being here to watch the nervous young scholars defend their ideas, as Paul de Hert put it yesterday at the opening. This is a bit low-tech now. I mean, yay. I think that's enough of a slide for me. In my article, I'm using a concept from political theory as a benchmark for automated profiling. And I decided not to try and retell you the article here in 10 minutes. Instead, I will tell you why I wrote it and then share some of the key findings. I think neo-Republican theory can make some abstract problems with profiling very tangible. One major advantage is that we don't need to rely on individual feelings or piecemeal arguments, but we can use this as a very coherent framework. And of course, people can be more or less creeped out about ads following us around on our screens and other known issues. But this theory provides some clear criteria to find out what is structurally problematic and what is not. And the second remark on why I like this theory is that I work for a think tank in digital policy, and I hear all the time how our laws don't keep up with tech developments and that we need new guidance and ideas to catch up. And of course, that's somehow true. Yesterday in this room, we heard about the challenges, for example, of treating Uber as a taxi company in order to make it fit into existing legal framework, or about not how all problematic practices are caught by the GDPR. And in this regard, I think developing the legal framework along with our realities, I think here higher level principles can be very useful. And I also think that the current trend to look at ethics is a good thing, not to have ethics instead of regulation and to replace laws with whitewashing, code of conducts and so on, but because it can give a good orientation in complex situations. And for the same reason, I looked at political philosophy. It provides orientation that we can then use to guide the more concrete steps to make hard regulation. So my idea is to share with you why, to me, neo-Republican theory looks very useful to address challenges related to profiling, smart environments, and personalization. And then ideally, the lawyers and engineers among you do the concrete steps in the future. Yeah. Okay, I will do without the slides. It's not important. I only had 3 slides anyway. It's fine. No, it doesn't work because I used PDF and not a PowerPoint presentation. Yeah, the neo-Republican concept that I use in my paper was developed by Philip Pettit, and according to him, for an individual to be free, she has to be free in her choices. The key word is freedom as non-domination, and domination exists when one or more persons have the capacity of arbitrary control over the choices of another. And the main forms of domination are interference with the choices, invigilation, and intimidation. And of course, laws interfere with what we can do all the time, but because they are democratically checked, they are not dominating in principle. The other 2 forms, invigilation and intimidation, can be conceived as domination by their pure existence, so without any interference at all. There's a popular image to explain this. A slave that is completely ignored by her owner and can do whatever she wants in her entire life still isn't free. That's because of her status. The owner could interfere with her choices with full discretion in a totally arbitrary way. And in this situation, an example of invigilation would be that the slave can do what she wants as long as it is nothing that her owner dislikes, like maybe drinking from her favorite cup. In that case, the owner would interfere and take the cup away. In the case of intimidation, the slave knows about this preference for the cup and never uses it, doesn't even look at it. That's intimidation. So freedom as the absence of domination means that there is no entity that can arbitrarily interfere with my choices, invigilate my behavior, or intimidate me in order to control my choices. So now let's check some examples of profiling and test them for domination. And of course, these are no yes or no categories. They both freedom and domination come in degrees. So profiling can be a tool for interfering with the choices of those who are subjected to the profiling. And that way it can intensify existing situations of domination. In the workplace, profiling can, for example, be used to interference from the management if you show the wrong browsing habits. It's also possible that new situations of domination are created because of profiling. In a regime that oppresses a certain religious group, members of that group might not pray in public because they know they are being invigilated. And then social media profiling might help to identify them and lead to another dimension of domination. And that's human intervention. So that would be interference on top of intimidation and invigilation. So we can think of many more examples, I think. I think intimidation is also very clear. In my article, I used a study about surveillance-related self-censorship on social media. So I will skip this for time reasons and talk about manipulation. So this is already less clear. According to neo-republicanism, manipulation is a dominating form of control. And I understand any attempt to bypass a person's judgment as manipulation. Now, when my GPS suggests that I take another street based on the short-time profiling of my location and traffic around me, that's a recommendation, and I can decide not to do it. My choices are kept intact. There's no domination. And targeted ads based on my search queries and browsing habits can also be considered as offers, and I can refuse them. So these are not problematic in principle. But there's a fine line between a suggestion and an attempt to manipulation. Examples include deceptive advertising for payday loans that were shown to people that were profiled as being in financial difficulty, or ads that were served to emotionally unstable teenagers. So this is domination and must be avoided. Now, it gets more abstract. The results of profiling can, in some cases, take their effect directly in our physical environment. A smart car that can detect the driver is tired with biometric profiling can either warn the driver or make driving impossible. In the first scenario, the control exercised by the car is non-dominating. It's a warning and the driver can ignore it. In the second scenario, the option to drive is removed. And that's maybe in the safety interest of the driver, but her choice is taken away. So we see that here, the profiling can be used in a dominating or in a non-dominating way. And that neo-republican theory clearly indicates which design option is the better one. And I think that there will be less clear-cut cases with the IoT where this can really be useful to decide. For the last point, automated adjustments to our informational environment already happen everywhere. For example, with search results or video streaming and so on. That's nothing else but personalization. And according to the neo-republican criteria, personalization is domination when the person has no control over the way that this happens. So the argument behind that is more theoretical, and you can find it in the article, but the bottom line is it's also domination if your choice options are being changed in relation to something that you value, and if you have no control over these changes. And that's empirically the case with any personalization that we cannot customize or shut down ourselves. So search results, news feeds, timelines, video, music suggestions, and so on. If all options, all offers to click on something are tailored to my profile, then all of my options have been interfered with. And that's even true if there are no genuine, non-personalized options at all. So I know that these examples don't seem very dramatic. That means that even if you don't feel dominated while watching videos, according to neo-republican theory, you probably are. And I find it interesting that this framework can be applied to the big questions of mass surveillance, and at the same time at such nitty-gritty contexts, and deliver the same imperatives that many privacy people demand, like democratic oversight for secret services, or a degree of control over the things that we see online, and so on. So can I have the last one?
If you hurry up a bit.
Yes. So I think that the requirements of non-domination are very useful in assessing if a given use of profiling is problematic. But there's one blind spot in an area that's very much discussed with regards to profiling. Non-domination focuses on a person's choice. So intimidation, invigilation, interference, it's all on my own range of options. Receiving a job offer or an insurance offer, that's external to my choice. But the persons who make these choices sometimes rely on profiling. So here we have a dimension with a high risk of unfair discrimination that we cannot conceive as domination. And that's maybe the weakness of the theory, because the benchmark doesn't work. It cannot be detected. But there is a solution. I will skip it for time reasons. And to sum it up, besides this blind spot, I think neo-republican theory can be very helpful. It can be used to evaluate the impact of existing profiling practices, can be used to assess new legal proposals regarding their democratic legitimacy. So the real-world aim of my article is this one little suggestion that when we talk about profiling and of its regulation, we could include the question, would this lead to or increase domination? And in my article, I collected more details on how to assess this. So if you want, you can take a look. Thank you. I hope the time for the setting up and all the logistics didn't count on my presentation, right?
Thank you so much. We have some comments by Maya Brakan. And after that, we open the floor for Q&A, some 2 or 3 questions from the audience. I can block the light.
Okay. I have to hold it, okay. Yeah, I first wanted to go very close to the author, which does not mean I agree with his opinions. But now, no, this is not sustainable. Oh yes, thank you. Thank you very much for saving my eyes. Eike, thanks you very much for this interesting presentation, and especially for the interesting paper that the whole jury read with delight, I must say. And with this very positive introduction, also congratulations to your paper, I would now like to go to a little bit more critical part, which obviously follows every such presentation of a nervous young scholar. So what you did very well in your article is put forward these different possibilities about how profiling can lead to dominance or to non-dominance. And I'm going to go directly into what you put forward as a blind spot, because this is the blind spot that immediately came into my mind when I was reading your article. So I still don't really understand why, when you are deciding about those who are being profiled, I understand why this is dominance. So as an example, you give an example of a Muslim taxi driver which preys on certain times, and from there it can be, through his profile, inferred that he is a Muslim. So I can see why this is an element of dominance. But I don't see why, if that same Muslim guy, on the basis of his profile, of his sensitive data, the fact that he's Muslim is refuse a job, why this is not dominance. And I think that should have been explained a little bit better. I understand that the theory is there, but you should have maybe done a step forward in order to inspire the theory and maybe say, well, the theory is actually lacking some understanding of modern society, and you could have also made this daring step to say, well, the theory should have been updated, so to speak. Secondly, what I was a little bit puzzled about is your example of surveillance that you also mention in your presentation. And you say that actually surveillance is an example of arbitrary control. And you refer to different judgments of the Court of Justice. Now again, when I read this, I thought like, well, this might have well been the case, but your article is about profiling. And the surveillance that the European courts have been dealing with had, in my view, very little to do with profiling, because we were dealing with mass surveillance. And mass surveillance entails that everybody in this room and in the world is being observed, maybe being profiled, but it is not the other way around, that on the basis of your profile, you would be surveilled. So maybe it would be good to try to find another example if you want to develop this further into, I don't know, a PhD or whatever. Okay, then I'm going to skip another article, which is, I have another theoretical argument, but I'm going to skip this. Next issue that I've been dealing a little bit with is what is the solution to that problem? So what you suggest at the end of your article is that new rules should be adopted for profiling. Now, we all know that we already have rules on profiling in GDPR and in directive, which you don't mention in the article, but I can understand why, because you want to maybe take distance from this Article 22 and Article 11 from the directive, but it would be very interesting to see how these existing articles fit within the Petit's theory, and whether they really offer a solution for non-dominance, and whether they can safeguard from this dominance that happens right now from the side of our profilers. And to bring this argument even further, I'm always wondering, more as a general thing, whether privacy is really the right field to regulate such profiling, because profiling does not necessarily only affect our privacy, it affects an array of issues and an array of fundamental rights that are connected with privacy. So I'm wondering whether with these new rules that you suggest, you want to have separate rules which are not embedded within the rules of privacy, and how would these rules look like? That's for the beginning.
May I reply very briefly?
Yes, but we have 5 minutes also for Q&A and answering this.
Okay.
Maybe it's better to first ask the audience to have questions.
To be very quick.
Okay.
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 Thank you. I'll be very quick on this. Okay, so for the last one, about the analyzing the articles in the GDPR, I think that's very interesting, and that should be done, but that would be another paper, the next one. And I also think, actually, yes, it should not be limited to privacy law. That's why I think the principles are useful, and then afterwards you can see which body of law or which combination can be good for that. Then about the distinction between surveillance and profiling. As I said, the freedom or domination come in degrees, and I think that the profiling is a very, very efficient tool to make surveillance actionable. And if people know this, they also are more intimidated. So I think there's a very close relation, and thank you, I will spell this out more in detail in the following paper then. And I absolutely don't think that the theory, the neo-Republican theory, needs an update, or that it doesn't no longer fit our reality. I just think it can be applied very usefully to parts of the problems with profiling, but not to this. And I think I for myself can accept this, but as long as we know, there's also need for another tool. But I think the rest is already useful enough. So.
I still understand why refusing somebody a job is not dominance.
Okay.
But let's go to Q&A maybe.
Okay, Q&A. Who wants? I think, I don't know how far we will come. Here first? Can you come here or not?
Hello, Andreas Corti from the Technisches Bürgernetzwerk Austria. The French have a saying, si vieillesse pouvait et si jeunesse savait, which means if old age could and if you knew, well, actually, I have now proved that you know. Because to me, I will not go into the details of your paper, but it's the approach that I cherish. I am middle-aged enough to have started on a Sinclair and then upgraded on a Commodore. And I remember what was the passion at the time. Now, the passion translated itself into providing an ideological template for what we did when we started out working on privacy. Unfortunately, I must say to people of my generation, young scholars today sometimes, perhaps too often, seem to fall into the trap of thinking that this is not about dominance, power, politics, but it is about reading as a palimpsest, written on parchment, the text of law. So I thank you very much for your approach, for providing a template, a heuristic, an ideological heuristic that helps us out. Thank you.
Thank you.
Hi, my name is Claudia Quelle and I'm at the Tilburg Institute for Law, Technology and Society. I'm about to say the exact opposite of what my gentleman before me said, which is that for me, philosophy is best understood as a means to further our understanding of the law. And that's actually inspired by a Republican idea, because it's because of republicanism that I do respect the law so, and that I think we can use philosophy to, develop an ideology that will help us have a vision, but not just on the basis of high-level principles, through an understanding of the messy reality that came about by our parliamentary or democratic decision-making. Yeah.
Okay, one last.
Yes, I'm not very well versed in neo-republicanism, but when listening to you, the domination issue you are describing is very similar to the passion for liberty that characterizes the liberalism, minimal state liberalism, of a Locke or a Mill as well. So I wonder what we can learn more from this neo-republicanism compared to the minimal state ideology that has dominated since long.
Okay, you have minus 1 minute to respond to this.
Me?
Yeah, if you want.
So that's good because there was just one question, right? Yes, I know. So for the new versus old republicanism, I would just say that the neo-republicanism is less demanding of the citizens. So we don't have to have the civic virtue to create our environment and the law, but we can be, instead of the authors of the law, the editors of the law. We only get active if there's something that we don't like. So I don't know, and I think that would need a lot of time, and we should maybe discuss this afterwards. Okay, why is it not domination if I get refused a job based on my profile? The people giving me a job have also an interest in not being dominated and not having their choice interfered with. So there's a problem if we look on that side. And they also have the right to get informed about decisions. It's just very theoretically, it was never my choice if I get this job, and it was maybe also not just before profiling. So we cannot conceive it as domination within the theory. I agree in the paper that this is not useful, and that we would like to have it differently. Yeah. It's a very hard question.
Okay. Now the second presentation.
Could you help me start it? I can't read the Dutch. Oh, perfect.
Yeah, and I think, yeah, it works.
Thank you. Hello, my name is Irene. My article was about the political dimensions of France's support for the online right to be forgotten. In March of 1998, France put the internet on trial. Well, it was a mock trial. It was it was the main attraction of the Fête de l'Internet. And it was approximately 70 people, expert witnesses, NGOs, participated in the trial, and the internet was portrayed by a young actress wearing silvery makeup, and she was accused of committing, among other crimes, accelerating social fragmentation and disrupting time and space. And then in March of 2016, we fast forward almost exactly 18 years later to the date, CNIL, France's Data Protection Authority, fines Google 100,000 euros for failing to respect French citizens' right to be forgotten. In 2014, there was a CJEU decision that recognized individuals, European citizens' right to be forgotten, to be delisted from search results that reference their personal information. And I think that my main argument is that this tension between Google and CNIL illustrates on the potency of France's attitude, even compared to its European neighbors, on the right to be forgotten and digital privacy. And so some scholars have noticed that, and they have explained it by saying, well, the roots, the intellectual roots of the right to be forgotten can actually be found in French law. They cite the 18th century droit à l'oubli, which gives former criminals who have served their time the right to have their criminal records expunged so that they can re-socialize into society. But other scholars have noted that that's not quite an accurate analysis because there's so many differences between that law ensconced in France's criminal code in the 18th century and the current national data protection laws. So that's where my research question comes from. It's what explains France's unique sense of urgency with regards to the digital right to be forgotten? And the answer I arrive at is that France's sense of urgency can be explained in large part by extra legal factors, political factors, rooted in France's enduring antagonism towards US digital hegemony. And I support this argument by taking a look at the seminal cyber policy documents in French political history since the 1970s, starting with the 1978 Nora Mink report, which was an administrative bestseller, and which is pretty rare, and was then translated into several languages and sold abroad as well. And that report outlined concern that France had about American domination of the computer industry. Then in the 1990s, and that report then was the theoretical inspiration for the Minitel telematics network that France later developed. In the 1990s, Patrick Bloch wrote a memo called Le Désir de France that took that further and discarded the old model and proposed that France start challenging the US on its own playing field of the internet, of the World Wide Web, but position itself as a Republican alternative for the Francophone world and for the rest of the world for how they handle digital information. And then the last document is the 2016 Digital Republic Bill, which I argue is the realization stage of what Bloch theorized in his 1990s memo. So from the 1970s to the present day, France has, while there have been turns in France's cyber governance policy, the key core political cyber policy ambitions have remained pretty stable. The first is to resist American digital hegemony, and the second is to fortify the French exception in cyberspace by outlining this alternative Republican model. And I would argue that France's advocacy for the global right to be forgotten in the present day represents, in part, the latest attempt to realize these ambitions. So I think the literature, in conclusion, has simplified to some extent the roots of the French attitude towards the right to be forgotten, and I would like to further complicate the narrative by offering some extra legal factors that I think give us a more complete explanation. And I hope that this line of inquiry prompts future research that in both empirical and normative directions that can facilitate cooperation and help us with Americans, with their European counterparts, develop some necessary and proportionate digital privacy standards.
Thank you. Yeah, but first my comments. I will give the microphone to myself. So this is one of the papers we are really proud of to have in Edpl. I think, as Nelly already pointed out, we have always focused on good legal articles, explaining the law in good detail, but also, as I think both papers do, theorizing on them and going a level higher or deeper or whatever you want, right? And this is especially one of those articles. Why the French is always the question we are dealing with. We're speaking right now in the Netherlands. There's a whole debate going on because we had a new invention of fishery, and now the French did a lobby to block these new inventions so as to protect their own way of fishing, the traditional way. And this is maybe the first question I have, and maybe you can explore that a bit deeper in your presentation, because you explained that French has always wanted to protect its own culture against the American influence, and you signal, I think, two ways in which you can do that: by developing your own culture, by the Minitel, for example, really protecting that, or the other strategy, which you also mentioned, is taking the global structure of the internet and trying to influence that and impose the French culture on that. And this is, I think, always a duality which you can see throughout the whole French history, but maybe you can expand on that. And the second thing, I would say three things. Second thing is the GDPR. How do you view that? Because this is one of the instruments which Europe uses to actually impose its own moral ideas on, among others, the US. But it has been often coined as a primarily German document rather than a French one. How do you see that? And the final thing is, why the right to be forgotten? Why is this the new tool for the French to hit the Americans with?
Sure, I think the Americans and our European counterparts, especially the French, have different notions about what privacy really is. In the US, we think of it as liberty. We want privacy. Privacy is us, the government, having safeguards in place to protect us from them, from the government. But the French don't think of it that way. They think of it as the government putting in place protections to protect them from each other. They don't, it's about dignity. And that is why I think it's the right to be forgotten, that it is France's way of exerting that difference, because the right to be forgotten, it's about personal information and search results. So it is precisely about protecting, shielding one's dignity from each other. And I think that goes back to pre-revolutionary and revolutionary times and the way the French have historically thought about privacy and how that conception has developed. I think you see it also in the French's idea of laïcité versus how Americans think about secularism.
Okay. Frederick had a question, or not? Yeah.
Hi, great presentation. I'm going to go home and read the paper in depth, but for now I have a question. Could you tell a bit more about your own opinion on your findings? Do you love the French view because it's funny and rebellious, or do you think it's faintly ridiculous, or do you have yet another view?
It's a great question. I have a great affinity for the French. I was a French major at university and a government major. I do think that in the US, the right to be forgotten will never exist, probably because we have the First Amendment, which enshrines freedom of speech. And I think we balance rights, whereas the French tend to think of them in more absolute terms and don't necessarily, and tend to, I don't think they balance free speech, and they also think of free speech more as freedom of expression, whereas we don't really call it that. For us, it's enshrining free speech against speaking out against the government, for example. So I think the right to be forgotten has it's good in theory, but I think it is a little too broad. It's a blanket legislation rather than something developed and tested out over time.
Okay.
Peter Schaar, I come from Germany, and therefore I want to introduce a German perspective. The German jurisdiction knows the right to be forgotten as well, and before the digital age. There was a famous judgment by our constitutional court in, I think, 1973, the so-called Lebach case, saying there is a right to be forgotten or not to be republished after you have committed a crime, but you were sentenced and you were in prison and you come out and you want to reintegrate into the society, and then newspapers and radio stations are not allowed to name and shame you again, because this would have the consequence you cannot survive a life in a free society. So my question is to you: did you investigate how far in times before digitalization did exist such an understanding of a right not to be public in the French?
Yes, I did. I had 3 chapters in my thesis, and that was the second chapter, was sort of a historical cultural studies approach. Well, this one's more political. And yes, the French, that is very similar to the French concept of the le droit à l'oubli, the right to erasure. And that's exactly, and the Germans and the French, you're right, they share that concept, but that's exactly why that tracing the current French attitude towards the right to be forgotten to that archaic French law, that's one of the reasons why I don't think that linear, you can't draw a linear link from the current right to be forgotten to that old concept, because it's not uniquely French. It is also German, and it's common in civil law. I think it's civil law tradition, that idea. So that's why I focus on this chapter on French cyber governance policy, because I think that's really what's unique. It's unique that France created Minitel, a national telematics network, and that it was such a politically charged technology. When you read the reports about Minitel, it's positioned constantly as like an alternative to American digital hegemony and computer industry.
Okay, the final.
Yes, I would like you to suggest another path of research, because I think the issue is linked to the fact that both the French and the German legal systems, in civil law, but in a strict European sense of the word, not constitutional, not public, but civil law, they both recognize personality rights, Persönlichkeitsrechte ou les droits de la personnalité. And these are absolute prerogatives one is supposed to have about information concerning him or her, and that involves the right to be forgotten. And we have it in authors, in copyright law as well, the repension right. You take out of the circulation works you don't recognize yourself anymore into as an author.
Yeah, I think personality rights is the legal explanation that completes these extra legal factors. So yeah, I definitely agree.
Okay, thank you. Now for the final presentation. We can clap as well, maybe again. And you will just sit down.
Good afternoon, everyone. Before starting, thank you to Lexon Publisher, and in particular to Nelly, Bart, and all the members of the jury for giving me the opportunity to participate in this conference today. I feel very, very honored to be here, and it is with humility that I will try to address some issues of the privacy shield, a topic that has already been discussed many times and again during this conference. I'm not going to explain again in the little time I have what is a privacy shield. I think we pretty all have a good understanding of that. Instead, I would like to focus on whether we can consider that trust has been restored a year and a half after the decision being adopted. The data published so far illustrates the fact that the US companies trust the newly agreed privacy shield. According to the privacy shield list, on January 23, 2018, 2,634 organizations had self-certified to the privacy shield. Of these companies, 1,172 had chosen DPAs as their alternative dispute resolution mechanisms. What this number says is that in a little more than a year, the number of companies that have self-certified to the privacy shield is pretty close to the one from the safe harbor after 15 years. Also, DPAs are not yet the alternative dispute resolution mechanism choice for the company. Only 39% of the company have uniquely recourse to them or in combination with other independent mechanisms. Now, whether trust has been restored on the EU citizen side is a much more complex issue for 3 reasons. It is true that the privacy shield is a step towards better protection in the EU, to the extent that the privacy principles which govern data flow for commercial purposes have been reinforced in the new shield. Moreover, to comply with the Article 47 of the Charter, the effective judicial requirements, which was recalled by the European Court of Justice in the Schrems case, new legal avenues have been introduced. However, some elements are still issues of good concerns. The first point I wanted to mention is regarding the introduction of these new legal avenues. EU subjects are facing a very complex structure to get redress. It is advised that they go first to the US company to solve their claim, and if the US company does not provide a satisfactory response to the EU individual, it can turn to the independent arbitrator, which can be a DPA or another independent arbitrator, and if it's not the DPA, they can still refer the complaint to the DPA, which will transmit it to the Department of Commerce or to the Federal Trade Commission. And as a last resort mechanism, the EU citizen may invoke arbitration through the Privacy Shield panel, which has, however, no power to grant monetary relief. So if EU citizens seek compensation for his loss, he will need to go before US courts using the Federal Arbitration Act to get damages. So, as of October 2017, neither the Department of Commerce, nor the FTC, nor the DPAs had received any complaint from EU individuals. But it's not really surprising. Maybe everyone is fine with the way data transfers are regulated, or maybe no one knows about it. But one thing is pretty sure, it will need a lot of courage for EU citizens to get into this very complex procedure. That's why, from what I studied, I'm not sure we can talk about an effective remedy. For me, an effective remedy would have been for EU citizens to be able to lodge a complaint before the member state national courts and claim damages there. The second point I wanted to mention relates to US public authorities' access to personal data on grounds of national security. The Commission has considered in the Privacy Shield that the US administration brought sufficient guarantees to limit the interferences with fundamental rights. The most controversial legal basis was Section 702 of the 2008 amended Foreign Intelligence Surveillance Act. It basically authorized the Attorney and the Director of National Intelligence for the targeting of personally reasonably believed to be located outside the US to acquire foreign intelligence information, which is based just on an annual certification of the FISA court. This program has been used as a legal basis for the upstream EMPRIS program of the NSA to pursue programmatic surveillance. Section 702 program was supposed to expire in December unless reauthorized. Several improvements were expected in case of reauthorization. The Article 29 Working Party, in that sense, highlighted in its report of the first joint annual review that, and I'm quoting it, instead of authorizing surveillance programs, Section 702 should provide for precise targeting, along with the use of the criteria such that of reasonable suspicion to determine whether an individual or a group should be a target of surveillance, subject to stricter scrutiny of individual targets by an independent authority ex ante. However, on January 2018, the US Congress voted the extension of this program for 6 more years without any significant changes. When it comes now to the judicial remedies available for EU citizens where US public authorities are accessing their personal data, the current form of redress do not seem to comply with Article 47 of the Charter. The Judicial Redress Act of 2015 extends some rights conferred by the Privacy Act of 1974 to citizens of designated countries. Thus, EU citizens may be able to challenge before US courts the disclosure, use, and inaccuracy of their personal data by government agencies. But according to Section 2A and B of the Judicial Redress Act, actions can only be pursued against a designated federal agency or component. However, the NSA, CIA, and the FBI do not belong to the current list. So it does not provide any form of redress for EU citizens if they want to challenge before US courts the NSA surveillance programs. Moreover, a new oversight mechanism has been introduced in the Privacy Shield to deal with EU citizens' complaints in the sphere of intelligence community. It's the ombudsperson procedure, which is responsible to verify whether US authorities have complied with US law. However, until now, no ombudsperson has been appointed yet. Judith Garber is just acting as ombudsperson until the seat is filled. But also, there is no information on whether the ombudsperson decision is based on US agency reports or if the ombudsperson has directly access to the plaintiff's personal data. Also, these decisions are not subject to review, and there is no right to compensation in case a breach has occurred. The final point I wanted to mention today is that the strength of the Privacy Shield framework is based on the enforcement and oversight mechanism that were welcomed both by the European Data Protection Supervisor and the Article 29 Working Party. However, it has been a year since the FTC's action for enforcing the Privacy Shield is quite limited. 3 or 5 seats are still vacant, and it appears very difficult to ensure repercussions for non-compliance with the Privacy Shield because the Commission's quorum need to be composed of the majority of the people sitting on board. Similarly, the Privacy and Civil Liberties Oversight Board, the PCLOB, which is a strong oversight body in that sense that it has access to unlimited agencies' documents and classified information, is currently limited in its actions right now. On the 5-member board of the PCLOB, only 1 seat is currently occupied. Consequently, bringing all my points together, I do believe that US companies rely very much on this new legal framework. That is a clear step towards better protection after the safe harbor. However, some improvements need to be made, especially as regards US public authorities to personal data, for not putting in danger the new Privacy Shield. Indeed, if this decision was annulled, it is uncertain that the new US administration will accept to adhere to the current commitments, not to speak of even stronger ones. And even if there were, it's not even sure that this time the US companies will place confidence in this new legal framework. Thank you.
Thank you very much, Anne-Laure Philouze. This was a very clear presentation of your paper and even beyond. I will tell you one thing. I didn't put any comments on the actual article, and there's a reason for that, and it's the Court of Justice. Whoops. The Court of Justice in Novak declared that comments on students' papers, and I regard this as something similar, which say something about the value, our personal data can be accessed. So from now onwards, no more comments by professors on papers, otherwise you might run into trouble. But actually I did write up some comments, and I will briefly go through those. The Privacy Shield is everywhere. It's discussed all the time. You said it, the conference here was opened by Privacy Shield. Yesterday there was a big panel. Today Schrems, Max was running around saying things about it, rightly so. And then you have a difficulty as a young scholar. What do you do with a situation like that? A lot of things have already been said. So how can you add an additional angle, or do you go back into the history of it, put it into context, which is necessary? You can't really jump directly onto, let's say, for example, the surveillance issue that you mentioned. And I think we can congratulate you on the way that you have managed to comprehensively put it into the beginning of the article, what is the Privacy Shield about? And then pick out 2 or 3 areas of big concern. And also the reason why we're talking so much about it, not only this year, but also in the past year, and it will be the same next year, is Schrems 1, that's judgment, was, and that is never to be forgotten, the first time that the court was considering the essence test. Has the essence of a fundamental right been violated? And that's why it's right that you pick the topic, even though others had already written about it. What I do think is necessary also when you continue to reflect on the Privacy Shield and its implementation, and basically along the lines what you said at the end, is to focus, to pick out certain things, and very specifically, like you said, for example, is the non-staffing of a review board a sufficient reason to say there is no compatibility with the Shield, or is that a temporary situation that one can accept? How long does a temporary situation go? And then maybe find also other areas of law where one could use that as a comparison. Are there rules about administrative, we have this right to an efficient administration under Article 42 of the Charter. Is it efficient if an administration is just not staffed? Some interesting thoughts that one can maybe go through. You have put the finger into the biggest difficulty, and that is the judicial review and the redress mechanisms. The reality is that the Privacy Shield foresees, if you want an exportation, or from the perspective of the EU, an importation of the review away from the US to here. And like you rightly said, and mainly page 467 of your contribution, that is where it is lacking. Some have volunteered to this DPA version, but it's not working. There are no second and third and fourth Max Schrems cases, not before the court, but before these boards. There is a reason to it. Maybe it's a lack of efficiency. We have to look at that as well. The second big area that you point out is the surveillance issue. And the question there, you rightly say that in actual fact, the way the Privacy Shield has been conceived means that the US has to be more privacy friendly than our surveillance authorities. Do you have a standpoint on that? Is that fair? Is that not fair? There is a similar issue about the EU-Canada PNR agreement. The Court of Justice gives an opinion and says, no, we can't do that. But then afterwards we create an entry-exit system where we do exactly the same and even worse with the people coming into the EU. So treat our EU citizens good when they go through the world, but what we do with the rest of the world. So is it possible to have these two different standings? Maybe you can briefly elaborate on that. And in context with that, and that would be also an improvement I would suggest if you revisit, also take the US perspective. Because this is exactly an example where they say, what are you expecting from us? What do you want us to do, which is even more than what you're prepared to do? You could do that on the literature level. I know it's difficult from Europe to assess which are the big important contributions, but there are also more contributions from the US that I would pick up. And a very minor mistake, which even slipped our editorial work, and luckily you mentioned it as well. It's Article 1 is mentioned in your contribution of the Constitution, and my friends of the US, they would be very unhappy if I don't correct that First Amendment, right? So it's not the Article 1, it's the First Amendment, the big free speech freedom. But actually, using that perspective could be a second area where you could improve, where you could continue to work on. I would like to encourage you to not leave it at this contribution. Why? Privacy Shield today is an important moment to reflect, but it's much more important in 2 and 5 years from now. How has it developed? And when you do that, if you want to, start thinking even stronger about that idea. What is essentially equivalent? What is adequacy? Can we again find other areas of law to give meat to this, because that's where it's going to be decided. The next Privacy Shield decision will be decided on the concept of essentially equivalent, I think. What's interesting is, in your presentation, you did that much stronger. You took very clear positions. It was an excellent presentation, so even without PowerPoints, one can also give very clear and understandable presentations. Do that more when you write next time. Take a conclusive answer in the conclusion, say, trust has not been restored. Or, because you're very cautious, which is understandable as a young scholar, but if one reads your contribution, there is only one possible answer, and that is no. Trust has not been restored. The only problem is, under Trump, the word trust just doesn't go hand in hand, and it'll get even worse. That's a correct political observation, but the legal observation, I think, is clear when one reads it. And my final point is, today, as most of you know, Schrems 3 was decided. I call it Schrems 3 because it's not got something to do with the Privacy Shield or Safe Harbor, but it's the class action case, if you want. And you rightly also pointed out there is Schrems 2 pending at the General Court. Let's do the following. We agree that when those cases are there, you will either write the next contribution or you will make maybe a case note for Maya's section. I'm looking forward very much to that. Congratulations, and maybe you can comment on these 2 points. Thanks.
Thank you very much, Mark. Yeah, what you say is perfectly true about the essentially equivalent test. I think it's going to be the main issue right now, and I think my next article will be on what is adequacy. How can we, and we were talking about the right to be forgotten before, if we need to ensure an essentially equivalent protection as the one ensured by the GDPR, which will come in force in May, are we going to deal between the adequacy decision and the broader EU general data protection framework and with third countries data protection laws? Because you were saying exactly before, you have the First Amendment. I'm sorry for mentioning article. You have the First Amendment in the US. So I can't wait to see how they are going to deal with this kind of privacy differences between our countries, because I don't think there is a proper answer to that. Because it's what I was writing in my paper. I don't think you can also, because we have this essentially equivalent test, go against the US own approach on privacy. And it's also what you were saying about national security before. In the EU, we have the Article 4, paragraph 2 of the Treaty of the European Union, which basically protects member states, national security is a member state's competence. But we are asking the US to have to ensure an essentially equivalent protection to the one ensured by the EU. So basically, we are asking them we have broader expectations on the US authority on that. And I think this is kind of big concern. That's why I was writing in my article, I don't know how far can we go. So, yeah.
We have time for one question because Serge also has to award the prize. Is there one question or not? Very good, then we leave it with this. Serge, can I call you to step forward? You have the prize. It's also a surprise to the authors who the winner will be. Okay.
So, let me read the name that is written on this prize. There is written Edpl, Young Scholar Award 2017, and then there is a name, and then it is written winner. So you want to know the name? Well, the name is Eike Gräf. Well, so maybe yes, congratulations indeed. I think you have to look at the picture for. It's without pictures, the Edpl. So anyway, congratulations. I've been listening to the 3 presentations with a lot of interest. I have not been a member of the jury, so the choice is not mine, but I applaud the 3 candidates and especially the winner of the prize.
Well, no, thank you for being here. And if you want to submit a young scholar paper or have young scholars in your group, next year is the time. And otherwise, mail me or Nelly for submissions to the European Data Protection Law Review. Thank you for being here.